Ready, start. Once he is discharged, he is no longer an accused, full stop. However, on going through the aforesaid judgment, we are of the view that facts in Kesub Mahindra and facts in the present case are poles apart, full stop. Kesub Mahindra arose out of infamous Bhopal gas tragedy, full stop. A highly dangerous and toxic gas escaped from a tank in the Bhopal factory belonging to Union Carbide India Limited, full stop. As a result of such leakage, 3,828 human beings lost their lives, semicolon, 18,922 suffered permanent injuries, semicolon, 7,172 suffered temporary disablement, semicolon, 1,313 suffered temporary disablement caused by permanent injuries, semicolon, and permanent partial disablement was suffered by 2,680 persons, full stop. While 40 human beings suffered from permanent total disablement, a total of 2,544 animals died, full stop. Criminal proceedings were initiated against the company and officials belonging to the company, full stop. Charges were framed under sections 304 part 2nd / 324 / 326 / 429 IPC, read with section 35 IPC, full stop. Some of the accused persons challenged such framing of charge before the High Court of MP at Jabalpur, full stop. However, the High Court dismissed the criminal revision application, whereafter the matter came up before this court, full stop. In Kesub Mahindra, within bracket Supra, bracket close, this court, upon perusal of the material on record, held that charges under section 304 part 2nd, 324, 326 and 429 of IPC were not attracted at all, full stop. Framing of such charges against the concerned accused persons fell short of even prima facie case, full stop. It was observed that mere act of running a plant as per permission granted by the authorities would not be a criminal act, full stop. Consequently, in our view, taking the entire material as aforesaid on its face value and assuming it to represent the correct factual position in connection with the operation of the plant at Bhopal on that fateful night, it could not be said that the said material even prima facie called for framing of a charge against the accused concerned under section 304 part 2nd IPC on the specious plea that the said act of the accused amounted to culpable homicide only because the operation of the plant on that night ultimately resulted in deaths of a number of human beings and cattle, full stop. However, considering the gravity of the incident, this court exercised power under Article 142 of the Constitution of India and examined the question as to whether the material led by the prosecution could prima facie support a charge under section 304A IPC against the concerned accused persons, full stop. This court thereafter opined as under colon it cannot be gainsaid that the voluminous evidence led by the prosecution in this connection at least prima facie shows that the accused concerned who operated the plant on that fateful night at Bhopal could be alleged to be at least guilty of rash and negligent act in the way this highly volatile substance MIC was handled by them and which ultimately escaped in vapors form and extinguished the lives of thousands of human beings and animals apart from causing serious bodily injuries to thousands of others, full stop. However, for framing charge under section 304-A on the aforesaid material, it cannot be said that the said material even prima facie did not point out the culpability of the accused concerned in running a defective plant having a number of operational defects and in being prima facie guilty of illegal omissions to take safety measures in running such a limping plant on that fateful night which resulted into this colossal tragedy, full stop. The aforesaid conclusion of ours, comma, therefore, comma, would make out a prima facie case against accused 5, 6, 7, 8 and 9 who were in actual charge of running of the Bhopal plant and would require them to face the trial for charge under section 304-A of the IPC. Full stop. The aforesaid conclusion of this court and the consequential directions issued was in exercise of power under Article 142 of the Constitution of India, considering the gravity and magnitude of the incident. Full stop. Insofar facts of the present case is concerned, comma, the two deceased employees of appellant number 1 were undertaking the work of decoration of the front side of the shop. Full stop. As part of the said work, comma, they were working on the sign board which was approximately at a height of 12 feet from the ground level. Full stop.